The European Union has adopted its 21st package of sanctions against Russia. Adopted on 23 July 2026, the package introduces new measures covering trade, finance, energy, shipping, crypto assets, and sanctions circumvention. For businesses involved in international trade, the important question is not simply what has been sanctioned. It is, what should your compliance team check now? In this video, we highlight 5 areas traders should review following the latest EU measures. First, the scale of the new listings. The 21st package adds 218 individuals and entities to the EU sanctions framework, including 48 individuals and 170 entities. These listings can result in measures including asset freezes and restrictions on making funds or economic resources available to designated parties. For businesses, this means sanctions screening should not stop with the name of the immediate customer. Companies should also consider relevant suppliers, intermediaries, financial institutions, and other counterparties connected to a transaction. The practical issue is making sure your screening process reflects the latest sanctions lists. Second, export controls. The EU has added 51 entities to the list, subject to tighter export restrictions because of their connection with Russia's military-industrial complex, or sanctions circumvention. And this is important for companies operating international supply chains. Not all of these entities are located in Russia. The European Commission identifies 27 entities in third countries, including entities in China, Hong Kong, Turkey, Kyrgyzstan, India, Kazakhstan, and the United Arab Emirates. The measures also address products and technologies, such as certain metal powders and alloys, microelectronics, machine tools, and semiconductor processing equipment. For exporters, this reinforces the importance of checking more than the final destination. You may also need to understand who the customer is, who the end user is, where the goods will ultimately go, and whether an intermediary creates a sanctions or export control concern. Third, financial services. The new package expands transaction restrictions affecting Russian and third-country financial institutions. The Commission says that more than 100 Russian banks are now subject to transaction bans under the EU framework. The package also introduces a dedicated approach to third-country crypto asset services that may facilitate sanctions circumvention. For companies, this has a practical implication. A transaction can raise a sanctions issue not only because of the buyer or seller, but also because of the financial institutions or payment infrastructure involved. So sanctions compliance should be considered alongside payment and banking checks. Fourth, shipping and energy. The EU has added 41 more vessels to measures targeting Russia's shadow fleet, on top of the 632 vessels already sanctioned. The rules also expand attention to vessels providing services to the shadow fleet, including certain bunkering activities. The package also introduces further measures involving oil traders, refineries, and LNG tanker transactions. For companies involved in shipping, freight, energy, or commodity trading, this means vessel and counterparty screening remain important parts of sanctions compliance. A company may not be dealing directly with Russia, but the vessel, intermediary, service provider, or transaction structure can still require careful review. Fifth, the package introduces further import and export restrictions. The EU has expanded restrictions on goods and technologies considered relevant to Russia's military-industrial complex. The package also introduces additional import bans covering certain goods that generate significant revenue for Russia. For importers and exporters, this means reviewing product classifications and transaction details against the updated restrictions is important. This is where customs and trade compliance teams need to work together. Classification tells you what the product is, but sanctions compliance also asks, who is involved? Where is it going? Who will use it? And is the transaction permitted? So, what should businesses review? First, update sanctions screening against the latest EU listings. Second, review customers, suppliers, and intermediaries for potential third-country exposure. Third, check export classifications and end-use information. Fourth, review banks, payment routes, vessels, and logistics providers where relevant. And finally, make sure your compliance procedures reflect the latest legal requirements. The EU's 21st sanctions package is not simply a list of new names. It affects trade flows, supply chains, finance, and logistics. The key takeaway is simple. Don't review sanctions compliance only at the point of shipment. Review the whole transaction and the parties around it. For more practical updates on customs, sanctions, and international trade compliance, subscribe to Ask the Customs Manager. Stay informed. Review your controls. Trade with confidence.